Our next speaker, actually, he's just going to say a few words. I was talking to Judge Talbot, and I mentioned to him that Justice Bruiniers was coming into town from California, and he said that he would like to come out and welcome Justice Bruiniers to the summit, say hi to him, and say hi to all you folks. So, Judge Michael Talbot, you probably seen him in the paper recently. He's the chief of the Michigan Court of Appeals. He was in the paper recently for some work he was doing at the 36th District in Detroit. He's served on the Wayne County Circuit Court. He was a special administrator to the 36th District Court, which is obviously one of the busiest courts in the country. I'm not sure if any of the 36D folks made it here today, but some of the Wayne County folks probably recognize his name. So without further ado, Judge Talbot, I turn it over to you.
Good morning. You are in a very unique place. This building was indeed a seminary. It was, for the most part, completed in 1948, and the idea was it was going to last forever. Nothing lasts forever. There's a lesson in that, in what we're doing here today and what we're going to be discussing here today. The seminary needs changed, and all of the seminary work is now in Detroit, at Sacred Heart, at Chicago, and Linwood. And this building was at one point up for sale. And then Cardinal might have decided to take it off the market and put it to different use. And the Archdiocese continues to own it today. I was surprised how much Scott knew about the facility, and I'm curious later on to find out how he learned so much about it. This space did not exist that you're in right now. This is an add-on. But over here, as you can see, this would be where the chapel is. Campanile over here, and the seminarians lived in the back. And then they would scoot along the walkway. It's up here, and there's another walkway at the other end. This was designed from a seminary that Cardinal Mooney knew of in southern Italy. So when they were scooting along, they moved very quickly in the winter in Michigan. There was no heat put in the corridors along here. So there was no dawdling in the halls, that was for sure. Something that Scott does not know is that the undercroft over here, where you had your juice and coffee, was a chapel. And there were a series of altars and a chapel where Cardinal Mooney envisioned he would be forever. And so when he died, he was buried just about where you got your coffee this morning, in the ground. And then, because things don't last forever, whether it be the administration of courts or whether it be in the running of churches, the cardinal had to be displaced when this place went on the marketplace, and he now rests at Holy Sepulchre Cemetery. So that's where Cardinal Mooney was, and that's a little footnote to the history of this place. During the course of the day, if I see you, if you have something you want to ask about, skilled craftsmen were brought over. I don't think there were any women, and spent about a year doing the ceilings, the halls, a number of places throughout the building. So it's an interesting place, and I hope you enjoy your experience here if you haven't been here before. You're bracketed. You have 3 judges. 4. I saw Judge Viviano, but she's a business court judge. So nothing terribly interesting there. But you've got a judge from Alaska, and you got a judge from California, and you got me in the middle. Now the judge from Alaska, you'll be able to identify, given the fact that it's going to be about 78 degrees today. Judge Morris will be outside. He'll be wearing a bathing suit, worshiping the sun. The judge from California will be in here wearing sunglasses even inside the building. And I'm bracketed between the two if you want to try to get an idea yeah, there's the sunglasses. Thank you, Judge. I knew you'd have. I'm the kind of guy that would go out to a charity golf outing last Saturday and tee off in the rain. So that gives you a sense of my judgment. And that tee off, we say, oh no, it'll pass. Any minute now, it'll be over with. And we darn near got blown right off the golf course, as you may recall. I wanted to give you welcome on behalf of the courts of Michigan. One of the subjects that's going to come up during the course of the day will be mandatory filing. And I'd be happy to chat with you about that. I'll be around here during the course of the day. But there's some interesting questions that don't have answers yet as to mandatory. And so I'm not going to take up your time now, but I did want to at least plant that seed that I look forward to talking to you about that and answer any questions you might have. There is legislation pending. And the simple fact of the matter is that as to mandatory, there are lots of implications that go with that. And those implications haven't been resolved yet. So until they are resolved, we will not have mandatory. But the voluntary is quite interesting. Denise Devine, who heads up our IT for the Court of Appeals, Kim Hauser, who's a presenter here today from the Court of Appeals, will tell you that even on a voluntary structure that we now have and the Supreme Court has, Supreme Courts did not have e-filing until a short while ago, as you know. We utilize ImageSoft. And if you take the prisoner filings out, because those are still pretty much paper, Supreme Court is now saying that they are hitting 80% of their filings on a voluntary basis are coming in electronically. Now that's coming from, for the most part, us. And so our filings are better than 60%, that in 65, so almost at least somebody is filing electronically in every case. That's on a voluntary basis. So it's very interesting that the dynamics of e-filing have changed tremendously in a few years, and the culture has changed. The judge is going to tell you a little bit about it from a very sophisticated standpoint, is Judge Bruiniers. Now, Judge Bruiniers is an interesting man. He was a police officer in California and Berkeley during an interesting period in the late 60s. He was a reservist in the Marine Corps during that period of time, undergrad at University of California, Berkeley, as well as an honors grad of Bolt Hall, Order of the Coif. Went into the prosecutor's office after that. At some point, having prosecuted a number of cases and developed trial experience, went into a law firm, created a firm that he was a partner of for 18 years that did more business and commercial litigation, and particularly with emphasis on national and international clients and technology. Then went to the trial court in California for his county, did just about all you can do: criminal, family law, civil division, and ultimately in complex litigation, and at one point was the chief judge of that court. He was appointed in 2009 to the Court of Appeals for California, for that district, for the first district. And of interest, particularly to us, is the fact that he is a member of, and has been for some time, since the late 90s, a member of the statewide Court Technology Advisory Committee of the Judicial Council for the courts in California, and was appointed as vice chair of that committee by the Chief Justice of California. So, Judge, we are really grateful for you taking the time to be with us, and we welcome you here today. Please.
Before I start, just a quick show of hands. How many people are here from the court system? Okay, substantial number. And I'm going to give you a little perspective, my point of view, on issues that are primarily relevant to the court system, but I think they will sound a bit familiar to those of you in the executive branch as well. And I want to start with a caveat that I am giving you my personal perspective on this. I can't speak for the California courts. I can't speak for the Judicial Council, but I can speak from the point of view of somebody who's been involved in these issues, who's been doing this for the last 15 years or so. My view is that we're entering, or now in, a very, very different era for the funding and implementation of court technology. We've all had dramatic decreases in funding over the last 6 years in particular, I don't think that that's simply a blip and that we're going to be back to the traditional method of legislative funding for court technology in the foreseeable future, at least in my view during my tenure on the bench at least. So we're in a different time. I think we need to see what we can do within a very different environment, what's feasible to do, what can we do in the new environment. So what's it about? It's about budget, budget, and budget. 47 of 50 states experienced dramatic reductions in funding for court operations over the last 6 years. I think unless you're from North Dakota, Wyoming, or Montana, anybody here from those states? No? Okay, well, unless you live in one of those states, you've seen pretty serious reductions in funding for court operations. What's the new normal for technology in our state and I think across the country? Well, in California, we've got 38 million citizens. We've got 58 locally governed trial courts with about 1,700 judges across the state and about 340 commissioners or referees in those courts. Until 1996, all of our trial courts were funded entirely at the county level. So we didn't move to statewide trial court funding until 1996. In 1998, we unified all of our trial courts across the state. Now, one of the things that's a little different in our environment, I think that from what most of you have, is that the county clerk in our courts is not an independently elected local official. The county clerk in our courts is appointed by the bench, serves at the pleasure of the bench, and it serves as the CEO of the court. Another very significant factor in our environment is that we have an organized labor force in our courts. I know a number of states do not. We have an organized labor force of about 17,000 employees across the state. We have, I think, 122 different labor agreements with our represented employees. But those represented employees are very, very active in Sacramento, very politically influential, far more so than we judicial officers are. Another factor is that we only have about 20 attorneys that are members of our legislature out of about 120. And of those 20, probably 10 of them have ever actively practiced law. So they don't particularly have a lot of familiarity with the court system and with term limits. About the time they develop any knowledge or expertise, they've moved on to another office. We have 6 appellate districts. I serve in the 1st Appellate District with about 105 justices covering the state, and then 7 members on our Supreme Court. We have a Judicial Council, 21 voting members, 11 advisory members. They're appointed by the Chief Justice who chairs the Judicial Council. We have legislative and bar representation. Judicial Council establishes branch policy, makes the budget allocations within the branch, but does not have a lot of administrative authority over the individual trial courts. The funding model we have for our courts is complex, it's collaborative, it's time-consuming. The Judicial Council allocates the money to our courts primarily from what we call the Trial Court Trust Fund, with the recommendations of a budget advisory committee with 15 judicial officers, 15 CEOs. The formula for allocation of our state budget for the courts has traditionally been based simply on what money was provided by the counties at the time we switched from local funding to state court funding. And that resulted in some real disparities between the courts. So we now have a model allocating funding on workload that we're transitioning to. It's being phased in over the next couple fiscal years, but As a result of that, some courts get more money, some courts get less, but bottom line, it's a zero-sum game for all of us. We have a huge disparity in the size of our courts and the workload of our courts. The Los Angeles Superior Court has 431 judges, 140 commissioners, about 4,200 employees, and a $640 million annual budget. Compare that to one of our northern counties, Alpine County, which sits up at the northeast corner of the state, that has 2 judges, 3 employees, and a $600,000 annual budget. And there's an equivalent disparity in the courts simply in the IT resources that are available to particularly the smaller courts. Our labor costs are the single largest expenditure in trial courts, about 79% of our budget. Again, the state funds the court system, but employee compensation and benefits are all negotiated at the local level. Now, we've had a total loss of a little over $1 billion in court funding over the last 6 years. Some of that's been backfilled by essentially taking money from court construction funds, other one-time monies, but the net loss to our trial court budget has been over $1 billion. We're currently at about 2.2% of the state budget overall. We used to be a little over 3%. We're about 1.3% of the state general fund, and we get funded from about 16 different funding sources. Now, we did get more money this year. So the governor's 2015 proposed budget provided a little about $3.6 billion for the court system, and that was about a $90.1 million increase to support trial court operations. But that's far, far short of the $266 million additional funding that our Chief Justice has said we need just to be able to tread water. Now, in our state, we have what they call the May Revise, where we look to see whether additional revenue is available. And so fortunately with the economy, we had about $6.7 billion in additional general fund revenue that the state realized or is about to realize. Now, is that good news for the courts? Unfortunately, no. We have a tendency in California to do ballot box budgeting. So of that $6.7 billion by statute, most of that is required to go to K through 12 education, to paying down state obligations, and to funding a state level financial reserve. So out of that $6.7 billion, what did the courts get? The courts got $15.5 million out of that total, and most of that money is going simply to offset anticipated reduction in revenue from fines and fees. We took an additional hit to trial courts in a legislative and executive mandate requiring the courts to spend down local reserves. A number of courts had been able to build up some level of reserves, roughly a 2% reserve over a number of years. The legislature and the executive required us to spend that down to 1% over 2 fiscal years. So most of that money has to be spent or committed by the end of this fiscal year. Now, again, as I'll discuss in a minute, there are some positive and although unintended consequences that resulted from that. The other problem we have is that anytime we do get new money, the legislature is more than happy to try and tell us exactly how we should spend that money, where we should spend that money, and as I mentioned, our representative workforce usually wants a say in where we spend that money as well. So, what are the consequences for implementing branch technology? Well, we had what I think is a seismic change in direction in what we were doing in California in 2012. we had spent 7 years and about $315 million to successfully develop a single statewide case management system. And at the insistence of the legislature, we had outside analysis done to confirm the validity of the system. It was fully tested. The product acceptance testing was done. The independent reviews found that the system was, quote, well-planned and comprehensive, that it was scalable, that it would perform as designed once in the production environment. But the estimate was it would cost us about $500 million over a 10-year period to fully deploy the system statewide, and the legislature refused to provide any of that funding, and largely due to some political pressure from our representative labor force. So we were forced to take that product, put it on the shelf, and essentially abandon that effort. So what does that mean? Well, at the time we started development of what we called CCMS, California Case Management System, we had legacy systems statewide as a result of trial court unification from our old municipal courts and county level courts. I think we had at one point 253 different case management systems that we were using in various places across the state. Now, we're probably down to less than half of that now, but the reality is that we are going to continue to have, and I think the model going forward is going to be, multiple platforms, different case management systems used across the state. We will not have a unitary system, although we do have one for our appellate courts. So that's the only place we're going to continue to have a single or unitary case management system. And the political history and the fights that we had over CCMS will mean that trying to fund or deploy branch-wide initiatives is almost impossible. Now, we were asked by the executive branch, once we abandoned the CCMS effort, to come up with a new branch strategic plan, a new branch tactical plan for implementation of technology, and we were pretty clearly told that we would not be able to get funding for any technology initiatives unless and until we had that plan. So we spent most of the last 2 years developing new branch tactical and strategic plans. Those plans focus on use of technology, including e-filing, to restore public service, to restore public access to the courts, and to increase the efficiency and reduce the cost of court operations. Now, okay, we've got a plan. Now, how do we fund it? Well, the governor has told us that he wants the courts to be more efficient. The Department of Finance has told us that we had to have a tactical or strategic plan to be able to get the funding. But there seems to be a disconnect somewhere in Sacramento, because every time we submit a budget change proposal focusing on funding for technology initiatives, including a document management system for the Court of Appeal, for example, those are rejected. We haven't had a single budget change proposal accepted in the last 2 budget cycles. I'm not convinced that we're going to see any additional funding from the branch. So now that we have a new plan, now that we have a new technology vision, now what? Well, the Trial Court Trust Fund is essentially politically untouchable without consensus approaching unanimity across the branch. Again, remember, this is a zero-sum game for the funding. So getting money from that source is not going to happen in the foreseeable future. Our technology initiatives used to be largely funded out of what was called the Improvement and Modernization Fund. We use that money for court technology projects, for interpreters, court security, judicial education. It was funded by 2% of all the fines, penalties, and forfeitures collected in criminal cases, royalties received from publication of uniform jury instructions. It's been used to fund statewide programs like our statewide land WAN program, a financial system that we use for management of all of our courts, a statewide protective order registry, facilities management, and hosting of a number of our systems at the what we call the tech center. Yes. Now, that fund has been running at a structural deficit of about $11 million. A $6 million reduction was mandated for fiscal year 15-16. So that's reducing or eliminating funding for branch-wide programs and services, and it's reducing our statewide IT staff. So again, what's the new normal? The new normal, in my view, is that there is no legislative appropriated money at the branch level to fund any state technology initiatives. There is unlikely to be any legislative appropriated money for tech initiatives in the foreseeable future. We have some short-term funding, but it is one-time and local funding. Well, as I mentioned a minute ago, we actually have some opportunities that have been presented by the requirement that we spend down the local reserves. The courts have been using that money for acquisition of new case management systems. 34 counties are going to be acquiring one or more case types and using the reserve funds. Again, a lot of the current systems are legacy systems, county mainframe based, some dating back into the 60s and 70s. There's one court that's been using a system based on COBOL programming, and I think they have exactly one person who is capable of maintaining the system. And if that person is incapacitated or simply passes away, there is literally no one who can manage that system. So again, while it's one-time money, we're going to have perhaps 40, all told, new case management systems being implemented. Some of them currently are, and most of them are expected to be online again by the end of this calendar year or the first quarter of next year. Tyler Technologies has been the biggest beneficiary of that spend down requirement. I think they've got 25 of the county systems that they're building, counties of various sizes. So that opportunity allows us to focus on e-filing implementations that, frankly, a year ago I would have said simply wouldn't have been possible for us to do. How are we going to implement the e-filing? Well, it means that we have to focus on projects that we can do collaboratively, leveraging resources between the courts across the branch. It means that we have to have projects that have an immediate return on investment. Simply a long-term return on investment is not going to be the primary focus. Or we have to focus on public-private partnerships with initial investment to support the project coming from the private sector. So what can we do? What are we doing? Well, as I said, we need to leverage the existing resources we've got. We now have a much less centralized and a more collaborative decision-making process in our courts. We have, as part of our tactical plan, what we refer to as the Digital Courts Initiative. And the way we're trying to implement that now is really, well, there's really two ways. One is what we refer to as the workstream approach. The Court Technology Advisory Committee that I now chair sponsors collaborative work streams with resources gathered from various trial courts, participation from across the branch, from both the court executives, from judicial officers, from court IT staff collected from the trial courts. The work stream approach is, again, collaborative projects, very tightly scoped, limited duration, sponsored by one or more members of the Court Technology Advisory Committee, with very specific deliverables in a short time frame, business-driven with input from the trial courts and judicial council staff, without any upfront funding, and designed to provide a framework or a roadmap that the trial courts could adopt in whole or in part on technology initiatives. Examples of those, things that we're working on now. One is standardized data exchanges. With the multiple case management systems coming online, multiple case management vendors, the interfaces and the data exchanges that we have had in the past with our statewide justice partners are now outmoded, ineffective. So we are developing those interfaces in cooperation with our case management vendors and with our state justice partners, our Department of Justice, the DMV, Department of Child Support, and we're doing that on a very tight time frame. We're trying to develop remote courtroom video standards. We've piloted remote video appearances in counties like Fresno, where we've closed courthouses and court buildings. I think we've closed something like 50 courthouses across the state over the last 6 to 8 years, and over 200 courtrooms across the state over that period of time. So in Fresno, for example, with the courthouses closed, if somebody wants to make a traffic court appearance, they would have to drive, in some instances, 90 miles each way to be able to get to that courthouse. Well, we now have video pilot projects, fairly low-cost projects using, I would say, low-tech for the most part, to allow for remote video traffic appearances. So we're looking to expand that to other courts across the state. We're looking and evaluating, what is the next generation hosting environment going to look like? Are we going to have cloud hosting? Are we going to continue? We're going to have vendor hosting. We're going to have local hosting, statewide hosting. That assessment's underway. We're putting together a disaster recovery framework for the branch. One of the projects we're working on is looking at the feasibility of developing a separate portal for self-represented litigants. Again, we're trying to leverage existing resources and assets. We've been developing an interview process in connection with our self-help centers to allow self-represented litigants to complete judicial counsel forms. We're looking at the feasibility of having a single portal that would allow self-represented litigants to access that interview process, to complete the forms required by the court, and to then e-file or e-deliver those forms to courts across the state. One of the projects that we're focused on now is video remote interpreting. We certainly have vendors that are more than anxious to cooperate with us on that. We have a language access implementation task force headed by Chief Justice Tina Cuellar that I'm serving on as well. So another initiative that we think we can do at low cost, no cost, in cooperation with our trial courts and working with our vendors. Again, one of the main focuses of the digital court and the digital court initiative is on e-filing. Our Judicial Council has recognized the importance and the significance of e-filing and the effect it will have on court operations. We all, I think, understand the benefits that can accrue. Again, the Governor asks us to be more efficient. Well, e-filing, electronic records will have the potential to dramatically increase our costs of trial court operations, data entry, storage space, file retrieval, copier office supplies, postage. I think one study that was done in Manatee County in Florida found that the cost to maintain paper files was something like 57 cents per page. I know that our Orange County Superior Court did a study as they implemented e-filing, and they have mandatory e-filing in all case types now. Their view was that to receive and process a paper filing versus electronic filing was about $2.50 to $3 per filing that they were saving on each of those. Obviously, we reduce staff time looking for missing documents. I think anybody here in the court system knows that the experience of having documents misfiled or again, you're either unable to locate it or simply in the wrong file, where it probably remains forever. It reduces filing rejections. Filers have the ability to get conformed copies of the documents immediately. E-service is another major factor. Improved quality assurance in the automated workflows, and access to the file by multiple sources from multiple locations. Centralized processing, and ultimately the benefits of having an entirely electronic record, particularly for those of us on the appellate courts, a record that is portable, searchable, and shareable. And at any given time, I probably carry at least a half a dozen complete records on appellate cases on my flash drive. So, about a week ago Friday, we had an e-filing summit in San Francisco for the California Judicial Branch with participation probably from, I think, 40 of our trial courts. And that was to try and kick off what we refer to as a work stream to develop an e-filing strategy for the trial courts. To recommend to the Judicial Council a policy approach and to develop a deployment guide for the trial courts. We're also looking at the possibility of providing selection and certification from e-filing service providers. We don't really know at the end of the day what the model is going to look like, but at this point, the Orange County Superior Court, which is doing most of the e-filing in California, and again, at this point we have, I think, only 10 courts doing some form of e-filing and different case types, but Orange County has mandated e-filing in all non-criminal case types, and they're doing about 25% of the civil volume in the state on mandatory e-filing. But they've certified 14 different e-filing service providers. So the issues we're looking at now is, are we going to have a single e-filing portal or solution? Certainly one possibility. I tend to doubt that that's going to be the case. Who's going to build and maintain the e-filing solutions? Who will operate and support them? Who pays for it? Will we make e-filing mandatory? And civil and non-civil case types. We do have the legislative authority in our state to mandate e-filing. Oh, sorry, let me get back here. And are we going to limit the number of e-filing service providers? How many are we going to have statewide? Very much an open question. Will we push for fee uniformity across the state, particularly if we have multiple EFSPs? And how are we going to deal with the free filers, the indigent filers and the government filers? All open questions. We expect that we will be working on this work stream collaboratively with the vendors to try and come up with solutions, and our timeline is to try and get recommendations to the Judicial Council certainly within the next 12 months, because with the rapid deployment of the case management systems, events are kind of outpacing our policy at the moment. In addition to the e-filing efforts that we're trying to do at the trial court level, we have been, I think, quite successfully moving forward on a branch level project for appellate e-filing. We issued an RFP in February of 2013 based on our appellate clerk's development of requirements. The principal requirement of our RFP was that we have a solution that was of no cost to the court, because we had literally no money to work with at all on this project. And it had to be an enterprise solution, one that would work across the branch for all of our appellate courts. It had to integrate with our existing appellate court case management system. We do have a single case management system for all of our appellate courts across the state, across all of the districts. We thought we might have one or two vendors respond to our RFP. We actually had 8, including some substantial national companies. In my view, 6 of those 8 were very well qualified vendors. And we selected ImageSoft. We selected the True Filing solution. We went live with that in March of 2014 in the 1st district, the district I serve in. That was our pilot. And we now have 2 districts up. The 1st district, our 5th appellate district. The 3rd appellate district is scheduled to go live next month. The 6th appellate district will certainly go live before the end of the year, and hopefully in the 3rd quarter of this year. And we're actually I think we've got a conference call set on Thursday of this week to try and finalize a schedule for deployment. The intention is to have all of our appellate courts live on mandatory appellate e-filing by the end of next year, including our Supreme Court. And as I said, we have mandated e-filing. We have had, with the exception of the pro se litigants, we have an opt-in for pro ses. They can e-file if they choose to. I meant to get the statistics from our clerk before I left, but I didn't get the numbers. But I think my sense is that more than half of our pro se filers, again with the exception of the prisoner litigation, more than half of our pro se filers have opted in, are using the e-filing system. We did a survey of our users after 1 year of experience in the county, had very, very high level of satisfaction across the board. So I'm encouraged, and I think that we, again, will have a successful project. We'll have everybody on board, and within a year, and we will have at least an outline, a blueprint of what we're going to do in the trial court in that same period of time. So without money, without resources, without the prospect of additional money coming in at any time soon, we're still able to move forward. We're still able to get results, achieve some positive things for the court, hopefully generate substantial cost savings and efficiencies for the court over the course of that time. So, what conclusions do I have from this? Well, one, as Rahm Emanuel famously said, a crisis is a terrible thing to waste. So we have been forced to do things that we might not otherwise have done that I think are becoming productive. At least in our courts in California, the courts are now part of the sharing economy. The focus for us over the next few years is necessarily going to be, for the most part, not on large-scale projects, but on incremental change. As I said, for any technology project that we're going to pursue, either an immediate payoff and return on investment is necessary, and or the project has to generate a revenue stream that will pay for the project, kind of what some have referred to as the toll road approach. Now, there's some philosophical objections that can be raised to making our court systems completely or largely user fee based, but again, in reality, that without outside funding, that is going to be the norm for some period of time. So, for the foreseeable future, we will need to have partners who are willing to advance or to share the initial investment requirements for projects, again, like our Appellate Efiling project. And it doesn't matter if you can save enough money to pay the mortgage if you can't make the down payment. So, again, we're going to rely on our partners for that investment, public-private partnerships, and even partnerships with our justice partners to complete some of these efforts. Everybody knows about the 5 stages of grief, but and there's been plenty to grieve about in the loss of resources and funding in the judicial branch, but denial isn't really an option for us. Bargaining hasn't worked very well. Anger hasn't been very productive either. Depression is, I guess, inevitable under these circumstances, but it's not an excuse for doing nothing. So we're left with acceptance of the fact that times have now changed, and we all have to figure out how to deal with what looks to be the new normal in funding and implementation of court technology. Thank you.